Set. Good afternoon, everyone. My name is Ahmed Qureshi, and I'm the interim executive director for the Interfaith Conference of Greater Milwaukee. Thank you all for coming to our third Tuesday in March program. Welcome to those of you who are here in person, and as well to all of those who are online. We have a very interesting and timely presentation today on democracy, and specifically focusing on cases that are before the U.S. Supreme Court and a couple of other matters that are of interest. As is our custom, we begin our program with an opening prayer. Today, our guest religious leader is Rabbi Sherry Shama. Rabbi Shama is a Jewish life specialist. Her goal is to make Judaism accessible, fun, and engaging. She embraces this do-it-yourself Judaism and encourages people to find the things that elevate their lives spiritually. From challah in various shapes and fillings to Rosh Hashanah hikes, she believes Jewish connection can be found in everyday moments. She is ordained from the Hebrew Union College Jewish Institute of Religion, earning both a master's in Hebrew letters and rabbinical ordination, and also a master's in Jewish professional studies at Spertus Institute for Jewish Learning and Leadership. She has been a congregational rabbi and has worked at the JCC as well. She lives with her family in Milwaukee. Rabbi Shama.
Going to just move this down a few feet. As I begin this blessing, I want to start by introducing you to two rabbis of old. Their names were Rabbi Hillel and Rabbi Shammai. They are legendary in the world of the Talmud, and the Talmud is the oral law that was written close to 2,000 years ago. Both Hillel and Shammai were wise teachers known for their verbal sparring. When it comes to learning how to light a menorah for Hanukkah, or how to teach Torah, or whether or not to tell a bride she's beautiful, i.e. white lies, or divorce, or planting a tree, or when to recite a blessing after the meal, Hillel and Shammai frequently held different opinions from one another. In other words, they are famous for their debates. They offer us a wonderful example of civil discourse. In fact, the Talmud teaches, Elu Devarim Chaim, these are living words. For 3 years, the house of Hillel and the house of Shammai argue. One said the law is according to our position, and the other said, no, the law is according to our position. Does this sound familiar? A heavenly voice spoke and said, these and those are both the words of the living God, and the halakha, Jewish law, is according to the house of Hillel. But then a question was raised. Since the heavenly voice declared both these and these are the words of God, why did it follow Hillel? And the answer is because the students of Hillel were kind and gracious. They taught their own ideas as well as the ideas of the students of Shammai. In fact, from the discussions of Hillel and Shammai, we learned that there are at least two sides to every discussion. And it matters more how you express your opinion and how you incorporate listening, learning, and wisdom into your debate. This is truly how to engage civilly. As we think about today's topic, democracy in peril, we heed the words of Hillel and Shammai. Even as they famously argued and debated, they did so with love and kindness. We too need to remember that as we move forward and hopefully one day, God willing, uniting our country, our religions, and offering a platform for tolerance, that we heed the words of Hillel and Shammai. I end with another text about them They are famous in Jewish law. Every debate that is for the sake of heaven will endure. But if it is not a debate for the sake of heaven, it will not endure. What is an example of a debate for the sake of heaven? The arguments of Hillel and Shammai. When they debated, it was l'shem shamayim, for the sake of the heavens. Let all of our discourse be for the sake of heaven. May our teaching enlighten others. May we open our hearts to listen and serve with kindness. And may we be united in understanding and wisdom. May our debates always be for the sake of heaven. Amen.
Thank you, Rabbi Shammai. Our guest speaker for our program today is Attorney James Santelle. I don't have any speaking notes in front of me. I've known Jim for more than 40 years. The first time we met, interestingly, he and I were taking a class together at Marquette, appropriately enough, a class in constitutional law. And that was with Dr. Chris Wolf at Marquette. Jim went on to the University of Chicago Law School, and then he went on from there to clerk for Judge Robert Warren in the Eastern District. And then he worked for almost 30 years in the United States District Attorney Office for the Eastern District of Wisconsin, concluding his service with being the U.S. District Attorney appointed by President Barack Obama in 2010 and serving for 5 years thereafter. Jim is more than that, though, to the interfaith community in Milwaukee. Jim has always been even as a U.S. District Attorney, he was very close to the Muslim community in a positive way. After 9/11, coming and reaching out to us and making sure that the Islamic community in Wisconsin knew that the Civil Rights Division of their office was watching out for the Muslim community. And in that tragic shooting at the Sikh temple in 2012, Jim was there. And Jim has been a constant advocate for interfaith and supporter also of the commemoration events at the Sikh temple community through the years, including the 10th anniversary last August. Jim has also served as a legal advisor to the U.S. Embassy in Iraq. And he has continued after his retirement to be active in speaking out in public on matters of legal issues and concerns and educating the public. And we look forward, Jim, to your education here today.
Ahmed, thank you so very, very much. Thank you to the Interfaith Conference, my great friends and partners for many, many years. Thank you to the committee that brings us together today. And thank all of you for spending the next 45 minutes or so chatting with me about issues that, in following up on the rabbi's wonderful invocation today, are about debate among reasonable people, nonetheless having disagreements, but nonetheless engaging in what we are all about in America, that is discourse that is productive and meaningful and humanity inspired. So Rabbi, I thank you for that invocation as well. A perfect entree into our discussion today, which, as Ahmed said, is going to be about democracy in peril, because we're going to be highlighting specifically a couple of Supreme Court cases that are pending right now before the present term of the Supreme Court that could have a dramatic impact upon not only things like gerrymandering and how we draw lines in America, but also how we vote. And one of those cases actually was the subject of some recent activity as late as last week and even yesterday. So how much more current can we be than just that? JC, my wonderful partner here, is going to be serving also as my technician today. And so JC, let's go to the next slide here right away. We're going to be chatting about, we're going to give you some initial comments about the Supreme Court, again, just in the category of of civics generally. And as I said, we're going to be talking about two cases in particular. You see, let's do the next slide right away. And we'll give you some historical perspectives. Again, this is things that I suspect you all know, but I always find it's good for me and sometimes for you to digest this once again and recollect that our traditions today in 2023 come from 240 years of history here in the United States of America, and includes something called the United States Constitution. This is my dog-eared version of it. Yes, it's seen better days, but I use it all the time. I'm going to use it again today, in particular in connection with one of those cases, because it is in Article 3 of Section 2 that the federal courts are created. You can see the language right there. And James Madison, people like George Mason, others who wrote this, didn't give us a lot of instruction about how the Supreme Court would work, how the lower courts would work. They simply said the judicial power, the capacity of judges to decide cases, is going to be vested in the Supreme Court and inferior courts, and that's not a description of their status as human beings, but just the lower courts. Establish these courts in America. I'm going to leave it to the Congress to decide how to figure that out as the country develops and grows. That's almost everything the Supreme Court says. The Judiciary Act of 1789, one of the very first pieces of legislation enacted by our first Congress, gives meat, some bones, and to that language in the Constitution, and establishes for the first time a Supreme Court. Initially, our court had 5 justices, including a chief. And over the period of the next 100 years or so, that number has fluctuated up and down. Some other time we can talk about the political machinations that prompted that to happen. Very partisan things, both before and after the Civil War. At one point, it was up to 11. You know well about the attempt by a former president named Franklin Delano Roosevelt to pack the court, unsuccessfully in the end. But the reality is, you should know that the Congress, not the Constitution, can set the number of Supreme Court justices. That can be done legislatively. And so today, as we talk, because of politics, about the possibility of increasing or decreasing the number of justices on our Supreme Court, that's something that can be done by our legislature, United States House of Representatives, United States Senate, and signed off on by the president. The significance, of course, is that that same act also says that all the federal judges in America, including those that are right down the street here, the trial court judges, the appeals court judges, the Supreme Court judges, they have terms that last their lives, which means that they will stay in those positions. They're not subject to election, not subject to recall, with the exception of one small thing also in the Constitution. You can impeach a Supreme Court justice. It's happened once in our history. The Supreme Court justice was not removed by the Senate, but was impeached. You can do that. The 2 other ways that Supreme Court justices leave their office, as you all know, some of them retire. There are 4. There are 4 former justices of the Supreme Court. Quiz yourself right now on who those people might be. I suspect you know their names. And of course, justices do die in office. Ruth Bader Ginsburg recently, Antonin Scalia, and they create vacancies. Those are 3 ways that justices will leave the Supreme Court. And they stay there because of this language in the Constitution that talks about their being tenured while they're engaging in good behavior. And aside from the 3rd grade directions that teachers might give about behaving well, this language is meant to mean that their lifetime tenure is established and they will not be removed absent impeachment or death. 116 justices to this point. Significantly, in terms of demographics, I know this group is rightly very much concerned and focused on the diversity of our court. Only 6 of them have been women. Ask yourself once again who those may be. We'll see 4 of them in just a moment or so. Only 4 have been non-white. And as I said, 4 our justices are still out there doing some good things in terms of civics, education. I'll give you a hint about one of them. Sandra Day O'Connor is still out there, as are others. That is the chambers of one of the first Supreme Court meeting rooms. It's still available to see in the United States Capitol. That sketch down below is where the Supreme Court first met in its first year in New York City, had no action, no cases, believe it or not, whatsoever. And the first Supreme Court justice sort of bemoaned the fact that unlike the legislature, did not have a lot of work to do. Supreme Court did, in fact, get busy very quickly. JC, next slide. And during the course of its first years, began to make some decisions, rendering decisions about controversies between individuals. That's what courts do, right? People come forward, case in controversy, I'm challenging something. And the Supreme Court justices did in fact begin to describe not only what those cases would be all about, but began to describe what their role is. And so that man, his name is John Marshall. He wasn't the first Supreme Court Chief Justice, but he was probably the most significant one in all of our history. It was John Marshall who way back in 1803 in a case called Marbury versus Madison had to do with the dispute between, believe it or not, Thomas Jefferson and James Madison. Imagine that, an outgoing president and incoming president having disagreements. Who would have thought that could happen once again, right? And so in the course of this dispute, John Marshall took up the cudgel, if you will, decided to establish the territory for the Supreme Court. And for the first time in our history, which wasn't very long at that time, said, you know what? When it comes to deciding what the law says, we're going to be the ones who decide that. We're judges. We're going to make the decision to do that. And so he said, an act of the legislature across the way, the Congress, that is repugnant to the Constitution. Who decides whether that's right or wrong? We do. It was simply a proclamation in 1803 of that authority, emphatically the province and duty of us judges, our justices, to tell you what the law is. And if you think about that, you think, well, of course they do. That's the rule of law. That's how we interpret the rules, the roles rather, of justices. You can make an argument, of course, that the legislature should be the one to interpret the laws, right? They pass the laws. They should know what they meant. Maybe even the president should interpret the laws. He, or perhaps she one day, the president should be the one to tell us what the law means. In fact, that's not our system, because John Marshall, a couple of hundred years ago, told us that indeed the Constitution will be interpreted by judges, including the Supreme Court. Note significantly that between 1960 and 2000, that 40-year period, some, perhaps not all of you, most of you were awake and alive at the time. I may not have been awake always in school, but about 500 different pieces of legislation stricken down by the United States Supreme Court in a 40-year period based upon this invocation of authority from John Marshall. JC, next slide. During the course of the time that goes forward, of course, as I said, we've had well over 100 justices. And you know that this right now, as of last June, is the present constitution of the Supreme Court. You see there far on the right, that's Ketanji Brown Jackson. She is the most recently nominated and appointed justice. I'll begin over here on the left side. Amy Coney Barrett comes from our area, the 7th Circuit in Indiana. Neil Gorsuch from the 10th Circuit. Brett Kavanaugh from the Court of Appeals. That's the back row. Those are the sophomores on the court, if you will. Those are the most recently arrived. That's why they have to stand for official pictures. And the word is that, of course, Ketanji Brown Jackson, before her, of course, was Amy Coney Barrett, responsible for going to the door when the pizza arrives for their conversations about cases. So she is off to the far right there. In the front row, of course, right in the middle, that's John Roberts. He has been the Chief Justice of the Supreme Court. He's also responsible for something called the Administrative Office of U.S. Courts. He does a huge amount when it comes to administration. And yes, indeed, in a topic we're not going to talk about today, also responsible for issues about ethics, and has the potential, has the power, if he so chooses, to establish an ethics code for the Supreme Court, which right now is out there generally, but doesn't exist a whole lot. To his left, or to our right, that's Sam Alito. He is the author not only of many, many opinions, but also of Dobbs, which was issued just in June. And to Justice Alito's left, that's Elena Kagan. She is the only justice of the Supreme Court who is not previously a judge. She was the Solicitor General, your Solicitor General, under the Obama administration. And that is the person who argues cases before the Supreme Court. To John Marshall's left, to his right, our left, that, of course, is, let's start on the far around here. Sonia Sotomayor at the far left here. Also, of course, a member of the Supreme Court there among more senior folks, and Justice Clarence Thomas, just to the right of the Chief Justice. Those to the left and the right are the most senior justices on the court. And again, although I tend not to like the assignment of names to them, descriptions to them based upon their tendencies, because on a regular basis, Supreme Court members surprise us with the decisions that they make. The reality is that to the extent that there are liberals and conservatives, left and right, we typically identify Justice Ketanji Brown Jackson, Justice Sotomayor, and Justice Kagan as being the three sort of on the left or liberal side of the bench. The others in the conservative or even middle side. John Roberts on a regular basis finds himself appropriately in the role of the Chief Justice, trying to be in the middle, negotiate some bridges, if you will, to all of them. But that is our Supreme Court. And they are meeting right now in the 2022-2023 term, including, as you're going to find in just a moment or so, some actions that they're taking these days, these weeks, even yesterday. JC, next slide. And so a few more things before we jump into those cases that are pending in front of them right now. On a regular basis for the past 20 years or so, even more, they typically issue about 60, 70, sometimes even 80 decisions. And those are already coming out in cases that have impacts upon the people here in the United States of America. We anticipate that the great number of big ticket items are going to happen in May and June, maybe even in July. They wait till the very end to give us these major decisions, as they did last year in some major environmental cases, a guns case, and also, of course, the privacy rights case. Typically about 75 or so every term. And again, look at what they do. On a regular basis, over time, they have reversed about 70%, 72% of the lower court cases gets reversed. That's power, that's authority. If you don't think the Supreme Court is an important part of our government, take a look at that in and of itself. A couple more things about just demographics, people who appear before the Supreme Court, including this week, last week, and next week. In the last term, not this one, last term, out of the entire group, about 520 or so, 40 of those women. We've got some work to do yet in terms of advocacy there, 120 or so male advocates. And then where are the cases coming from this particular circuit? And again, they've identified about 63 of them already. And 14 of those are from the Ninth Circuit. The Ninth Circuit is basically California and Oregon, Washington, Hawaii, Alaska. They tend, as Ahmed and other lawyers in the group will know well, they tend to identify a lot of Ninth Circuit cases and reverse a lot of the Ninth Circuit cases because of this fight, if you will, often between their ideology and that of the West Coast and California in particular. We are in the Seventh Circuit, and that includes Wisconsin and also Illinois and Indiana. And from our circuit, the Supreme Court has taken two cases. One of them, we're not going to talk about it much today, involves Medicare and Medicaid and the future of that institution, a major, major case. Look for that again in June. And many other cases from around the country. The Second Circuit is basically New York. That's why it also has a lot of cases coming out of it. And again, just because I always get asked, not by you, but by young people in school, how much do you make? And so there it is. You see how much the Supreme Court makes. Justices, associate justices, a little less than the Chief Justice himself, perhaps one day herself as well. JC, next slide. And so one of my favorite charts gives you some sense of where these cases come from. You can see we're in the lime green there, that's 7. When Ahmed and others appeal something from the federal district court right here in Milwaukee, you go to Chicago. And then if you're dissatisfied with the result of the appellate court, you go to the Supreme Court. And cases, again, from around the country, there you see the Ninth Circuit. Look at the huge geography of that. The Fifth Circuit is once again routinely in the news, including perhaps an abortion matter that they will be deciding fairly soon as well. The 11th Circuit was in the news a lot last year when it was resolving whether or not a district court judge in South Florida that was restricting an investigation into something involving some documents the former president had at Mar-a-Lago. The 11th Circuit basically told a district court judge in South Florida that she could not do what she was doing. Again, many of these cases, not all of them, can percolate up to the Supreme Court, but those are appeals courts. And again, all of that created by what entity? By the legislature, by the Congress, right? All right, JC, next slide. And so let's talk about a couple of cases, and I suspect you know very well what gerrymandering is about. This is the first of 2 cases, but I love this slide because it does 2 things. It gives you history once again. A fellow named Eldridge Gary, he was one of our founding fathers, went on to be the governor of the Commonwealth of Massachusetts. And while he was the governor of the Commonwealth of Massachusetts, he decided to draw some lines, yes, with the support of his legislature there. He drew some lines, just as we do here in Wisconsin, and drew the lines in a way that probably ensured that his party would remain in power, at least for his term and perhaps beyond. Again, sound familiar? And the local media got a hold of this. Obviously, opposition got a hold of this and said, look at what you're doing, Governor Gary. You're drawing these lines in a very, very peculiar way simply to ensure that your particular party remains in power. The Boston Herald, I think it was, looked at this and said, gee, it looks kind of like a salamander, what you have done. And they added the claws in the face. And this appeared then in the local newspaper. And it became over time gerrymandering, again, mispronouncing the governor's name. And that's where it comes from in Massachusetts, and the things that he did to draw these very peculiar lines in Massachusetts many, many years ago. Let me do a little bit more just to help you understand, not something that you don't understand already, but to help you understand this matter for the case we're going to talk about in just a moment or so. And that is, what is gerrymandering? Let us suppose we have a jurisdiction. Could be the state of Wisconsin, could be a subset of that. But in our particular jurisdiction, if you look at those three blocks, all three of them are exactly the same in terms of the composition of the population. You have got among the 15 people, again, this is just an example of how this would work. Among the 15 people who reside in this particular block, you have got what I will describe as 6 oranges, and you've got 9 plums. Okay, you might substitute your own political views for that, but you've got basically 6 oranges and 9 plums. Every single one of those boxes, even though the lines are different, are exactly the same in terms of where those plums are located and where the oranges are located. Okay, and so look what you do. If you look at block A, and you say, well, gee, I'm going to draw some lines to establish 3 different districts, 3 different voting areas. And I'm just going to draw some lines right down the middle. That seems kind of fair, right? Well, look what you do if you do, in fact, go down that road. You draw that straight line, seems sort of decent, but what you create then is the unlikelihood that the oranges will ever have a successful election, right? Presuming oranges will vote mostly for oranges, plums will vote mostly for plums, and you've drawn lines so that in each one of those districts, the plums outnumber the oranges, right? And so what you've basically done is you have cracked the authority of the oranges in such a way that they will probably never, ever have representation in whatever the entity is that you're electing. That's called cracking on the far left. To the far right, let us suppose that somehow the oranges get a hold of this and they do something called packing. Look what the oranges have done at that lower level area. You've got 5 different plums, right, in one district, and you know the plums there are going to win, right? But look what the oranges have done in the other areas. By packing all of those plums into that one lower district, they have created districts where they will probably win. Why? Because you've got 3 oranges to 2 plums, 3 oranges to 2 plums, and suddenly now the minority oranges are probably going to get overrepresented in this particular legislative body just by virtue of where the lines are drawn. That's called packing, okay? Left is cracking, right is packing, because you're packing those plums into a particular area and creating the likelihood that I, as an orange, will have a greater impact upon legislation and therefore be successful in voting as well. And then finally, you look at the middle, which again is not perfect, but probably what you're approaching, what you want to try to do when it comes to doing some reasonably decent line drawing. You do something, you kind of create that cross type figure right in the middle, and look what you've created. In the lower area, all right, that's you got 1 orange and 4 plums. Likely that's going to be a plum-centric district. But you look on the top and you say, okay, you've got 3 plums, 2 oranges, again, probably going to be a plum majority district, but a possibility maybe that if one of the plums goes over to the other side, you could get an orange. But you've also created right in the middle a district where likely the oranges will be successful, right? 3 oranges and 2 plums. And the result of what you've done right in the middle there, unlike cracking and packing, is you've created a situation where among the 3 districts, 1 will probably be majority orange, 2 will be majority plum, and that's pretty much close to the 9 to the 6 numbers that you've got overall. It's not perfect, but that's sort of the goal. And so our Voting Rights Act, JC, next slide. Voting Rights Act kind of contemplates that that's what legislatures will do and what the people that we elect to those legislatures will accomplish. What happened? Well, as you know, right here in the state of Wisconsin, we had, as we have in every state of the United States, we had a census, right, in 2020. All of us told the Census Bureau where we live, all kinds of other information. And in particular, we counted the number of people. That is also in the Constitution, believe it or not. James Madison said every 10 years, there will be a count of the number of people in this brand new thing called the United States of America. So we do that every 10 years. We did that in 2020. You all participated in that. As a result of that, every single state in the country went back and said, okay, here is our number in the state of Wisconsin. Here's our population. Here's where we're located, right? And as a result of that, the legislature then comes in every single state and draws lines. They draw lines here in Wisconsin for the state assembly and the Senate, our two legislative houses, and they also draw lines for congressional districts, right? And those are all premised upon the notion that you want to have lines that are reasonably close to sort of that middle section that I described before. You want to ensure that the population is very roughly the same. Doesn't have to be perfect, roughly the same from district to district, all right? And can you take into account things like rivers and mountains and major commercial areas? Sure you can. There's no requirement that you do this absolute precision, but you want to have some decency and fairness, and you don't want to do what Eldridge Gary did, which is you draw lines to create a salamander in the Commonwealth of Massachusetts, and that is plainly intended for some political purpose. So here in the state of Wisconsin, as you know, we did that. A brief recollection of the history here. The Republican held majority of the House, the Assembly and the Senate came up with a plan, as did our governor of a different party, as did many other entities. I suspect some of you participated in some of those fair maps and other groups out there who are likewise drawing lines, recommending neither packing nor cracking, but ways in which we can do this fairly in the state of Wisconsin. There was a dispute about that, right? The Republicans came forward with their plan. The governor said, I don't like that one. He basically vetoed it. He came up with his own plan. This ends up in the state Supreme Court in the state of Wisconsin. And lo and behold, the Supreme Court says we're going to adopt a policy that is the least change from 10 years ago. And an awful lot of people said, gosh, where did that theory come from? And it was maybe made up of whole cloth. But the impact of that was that everyone sort of anticipated, okay, least change means we're not going to change a lot of lines. And the Wisconsin Supreme Court came back surprisingly after this entire process was through and said, you know what? I'm going to choose the governor's plan. And it was a surprise to many people. One of the justices named Brian Hagedorn was the deciding vote on that. And it went up to the Supreme Court from our state here. And the Supreme Court looked at it and said, for circumstances that I won't get into right now, because you're doing this voting rights analysis, you didn't do it quite right, Justice Hagedorn. You didn't do it quite right. And so sent it back to our state Supreme Court. And the state Supreme Court on the second cut came back and said it's a little bit late. This is not perhaps the most sophisticated way to do this, but we're going to choose instead the Republican legislative package. And that's what we had here in Wisconsin. And that's how we voted in 2020 and beyond. All right. Same thing happens, not with that precision, but every single state, including Alabama, does the same thing. Okay. In 2021, they also look at their population and they draw lines. Without going into that great detail in Alabama, what they do is they basically got 7 different districts. And just as we have here in the state of Wisconsin, number of districts, and the legislature in Alabama, where the population is about 28% Black, 28% people of color, the legislature looks at that and says, well, probably very roughly out of 7 districts, you might have 2 majority Black districts, very roughly, at least more than 1, probably 2, given the population of our state. But the legislature in Alabama draws the lines in such a way that only 1 of those districts there is majority Black, okay? The matter comes up ultimately to the United States Court of Appeals, a 3-judge panel. Again, yes, in the 5th Circuit, talked before about where that's located. And this 3-judge panel, surprisingly at that time, says, you know what, legislature, you got it wrong. You got to go back and ensure that when it comes to line drawing, that people of color in Alabama have a greater representation. Maybe you're doing a little cracking or packing here. Go back and try it again, all right? And they send back the entire process back to the legislature because Section 2 of the Voting Rights Act, they say, has been violated. You are disenfranchising people here in Alabama by virtue of their race. And that is contrary to the statute that was passed in 1965. What happens next? Well, the legislature says, oh no, we're not going to listen to some federal judges telling us what we're doing. Instead, we're not going to just simply abide by that. And JC, next slide. We're going to take this up to the United States Supreme Court. And we're going to have the Supreme Court decide whether or not what we have done is proper or not. And about a year ago, when this first was percolating up, again, before the elections in 2022, the Supreme Court had voted at the time, basically said, you know what, it's too late. This is, again, our federal Supreme Court, too late to do anything. We're going to keep everything in place for Alabama, even with the gerrymandered lines, the one district that's majority Black, remaining 6 not majority Black. Not perfect, but the Supreme Court says about a year or so ago right now, but come back to us in our next term and we'll revisit this again. We'll take another look at this to see whether or not we should be re-examining this and either supporting or turning back the decision of the lower court that said that what you did there in Alabama was improper, okay? And so the case comes up to the United States Supreme Court in this term, the 2022-2023 term. And a little bit of civics here once again. You can go home and regale your family with this over dinner tonight. We're going to talk about Thornburg versus Jingles, which has been the traditional standard for many, many years in our nation. Thornburg versus Jingles basically says that when you determine whether or not you've done packing and cracking, whether or not you have disenfranchised a significant number of people based upon their color or their language or other immutable characteristics, you got to look at a number of different things. You got to do analysis. Got to look at demographics. You have to look, for example, of whether or not the population, in this case, African Americans in Alabama, are they sufficiently clumped together, if you will, in areas that you can draw without doing a Gary or a gerrymander. You can draw some districts that would make them, put them all, or not all of them, but the majority of them in some districts so their voting population is not cracked, right? And so that's one of the issues. And then also, can you find, and this is difficult to say out loud, but it's the reality, can you find that for the most part, that when white Alabamans vote, they tend to vote for white Alabamans, and when Black Alabamans vote, they tend to vote for Blacks, kind of our orange and plum situation before. Not with precision, but the upshot of Thornburg versus Jingles is you have to do analysis. And there are about 5 or 6 different things you got to take a look at to figure out whether or not you're in violation of the Voting Rights Act. Take a look at this. I will say in another context, this is about science, right? It's about demographics. Let's get the scientists in, let's get the statisticians in, the demographers in, and tell us how we can do this most fairly, okay? The state, the legislature, again, coming up from this lower decision, says to the United States Supreme Court 2 things. One is, we didn't illegally gerrymander. The Court of Appeals, the lower court, got it wrong, so overturn their decision and keep in place the 6-to-1 vote arrangement that we have right now. So don't overturn that. And second, and this is why Peril versus Milligan is so incredibly important today, and this is one that you do want to talk to your friends and family about tonight, argued on the first day of this term, what the Alabama legislature says is, get rid of Thornburg versus Jingles. Get rid of analysis. Don't look at those kinds of things anymore at all. Drop kick about a quarter century of tradition when it comes to figuring out whether or not gerrymandering has happened. And look at this. I'm going to read it out loud and then I'll unpack it. The state says that basically a rejection of the standard. Here's the new test that the folks from Alabama and the legislature are advocating for. You should invalidate a map. The lines we've drawn is wrong. Only if it's configuration, only if the lines are drawn based only on racial discrimination, right? That's a huge, huge change, right? And so, and under what circumstances would you find that, right? You can only invalidate lines being drawn if someone in the legislature stands up and says, I'm doing this because I don't want those Black people to vote. I'm doing this because I don't want those people of color to vote. Absent that clear articulation, it's the only reason I'm doing this, then we'll invalidate it. But if I can stand up and say, oh, but there was a river here. There was a mountain range here. There was a commerce area. There was I-43, I-94 split the particular area. There were some buildings here. I can come up with some other arguable, even if not credible argument that what I'm doing is not racially motivated. That will pass muster. And that's what the state of Alabama is advocating for right now in front of the United States Supreme Court. And on October 4th, again, the first day of the term, this is when we first heard from Ketanji Brown Jackson, who went crazy, appropriately, as did others, and said, you must be kidding me. This is a huge, huge change in the way in which we understand American justice and American voting, and we should not be doing this. And she talked about how the 14th Amendment was passed, basically to ensure that the franchise is guaranteed to people of color. And that's where this case is today. And the United States Supreme Court is going to determine, not just for Alabama, but for all of us, our future elections right here in the state of Wisconsin, whether or not Thornburg versus Jingles analysis, getting in there and doing the hard work of figuring this out, or if this very simple test that says the only way that a line will be drawn improperly is if it's only based upon a race motive. That's a huge change. And at the risk of sounding difficult on this beautiful Tuesday afternoon, that should scare you. That should scare you. And we will see again in June, Merrill versus Milligan. Merrill versus Milligan will determine whether or not in the future, how we are in Wisconsin and throughout the nation, our lines are drawn. Okay. Next slide. If that didn't scare you enough, and I think it did, this is going to scare you even more. Okay. Although there's a good news footnote here. The elections clause. I know you read the elections clause of the Constitution every single night. It is in section 4 of Title 1. It says the times, places, and manner of holding elections for senators and representatives, again, federal representatives, is prescribed in each state by the legislatures thereof. Okay. And I think, okay, that makes sense. You think about it when you go to the polls in 2 weeks from today, when you went to the polls for the primary election previously and in previous years, we don't have the federal government coming in. Who runs elections? It's the locals, right? It's the local clerk. You know all the clerks, you come and you see each other. It is not a federal entity that conducts elections. And decisions made about, as we have seen here in Wisconsin, the timing of elections, early voting, which is just opening today, absentee voting, where you can drop your ballots. Remember that issue from not too long ago? All those things are matters of state decision-making by the state legislatures, and yes, added on to by the courts, which is also significant right here. And every state in the union has a different variation on this. That's why when you go to California, for example, their rules say that every single person of voting age and voting requirement will get a ballot in the mail, because that was a legislative decision that the state of California made. All kinds of things. For the most part, it's not about hours, but again, all kinds of things related to how it is voting happens. We have seen, for example, in Georgia, the legislature passes laws that says you cannot give a bottle of water or a fruit bar to someone who's standing in line because, well, we're not sure. They came up with some theory about that. That's a legislative action being taken there, okay? Every single state, because James Madison told us this, makes decisions, all right? Still, even though we've got this patchwork and we would disagree with them, it makes sense. And that is how our country has been in place for 240 years, right? Until recently, okay? Now we're going to move from Alabama to North Carolina, okay? North Carolina does basically the same thing that Alabama does. And again, without going into great detail, North Carolina also draws some lines in the wake of the 2020 census and disenfranchises a significant number of people of color from voting in North Carolina. Same thing happens this time. That structure goes not to a federal court for reasons that Ahmed and others and I can only vaguely understand, goes up to the North Carolina Supreme Court, okay? Legislative action, gerrymandering goes to the state Supreme Court, and the state Supreme Court in North Carolina says, just as the Fifth Circuit said in the Alabama, no, you've done this wrong. You have not put this together in a proper way. Go back and do it again. Why? Because once again, you're disenfranchising significant numbers of people in our state who have a right to vote and have a right not to be packed and cracked, have a right to have their representation be on view and representation voting in the state legislature, okay? And the North Carolina, again, the Supreme Court says, you've done this wrong, go back. In addition, and here's where it gets scary, the legislature in North Carolina comes forward and says, in addition to objecting to your view that we have done this improperly, we're also going to take the position, hold on, that you, the courts, have no authority to decide this whatsoever, okay? The state court has no involvement in this whatsoever. Why? Because of this peculiar, and that's being generous, fringe, odd, offbeat concept called the independent state legislature theory, ISLT, okay? And the independent state legislature theory says that this language that I read from before that establishes that the times, place, and manner of holding elections precludes anybody else from doing anything else when it comes to rules and regulations. And they read that language to mean that the courts themselves are not to be involved in this at all, okay? And so when it comes to decision-making, the ISLT theory says, if you've got an objection, not only to lines being drawn, but yes, to the ways in which we conduct elections, you don't go to the courts at all. Where do you go? You go back to the legislature and have them decide about hours and about drop boxes and about early voting and absentee voting. Contrary, once again, to our entire system of checks and balances that says, yes, the legislature establishes things in the first place, but even if you don't like things here in Wisconsin and other places, you've got judges who look at that and say, well, is that reasonable? Are we doing something that's consistent with the Constitution, the Voting Rights Act? Courts have always been involved. The example I always used when I was U.S. attorney was this. People would come to me and say, what happens if something bad happens on election day, Jim? And I would say, you know what? If, for example, here's the best example of all, if there is voting taking place right here and at 7:59, the chief inspector looks at Ahmed, he's standing right outside here and he's come to vote and he's standing outside because he's got a very long line here. And he closes the door and says, nope, all you people who are in line, sorry, you weren't inside. I'm going to tell you to go home. What would we do? You would run to a judge, right? You say, you know, judge, Ahmed and all of his friends and his family and all of you are waiting in line. They're properly here. They just were delayed. And a judge would say, yes, that's right. I'm going to intervene. I'm going to tell you to keep that poll open. Maybe the people are driving up like I would at the last minute. Maybe they shouldn't be permitted to come in, but that kind of thing. It's kind of a silly example, but it does happen, right? And so judges always involved in this sort of thing until the invocation recently of this theory. It's been around for a while. It's been around for 25, 50 years. The North Carolina Supreme Court specifically says this, and this is wonderful language. The Supreme Court not only says that legislature has done this wrong, but we are rejecting the notion that we're powerless to review the legislative decisions. And what you're talking about, legislature, is repugnant to the sovereignty of the states. It is repugnant to the authority of the constitutions and the independence of state courts, and would produce absurd and dangerous consequences if you get the courts out of all of this, right? North Carolina Supreme Court says that. Legislature, just like in Alabama, says that's very nice, but we're not going to listen to what you say. We're going to invoke the possibility of going, JC, the next slide. We're going to go to the Supreme Court. And sure enough, in a case called Murr versus Harper, for the first time in our nation's history, the present United States Supreme Court is entertaining seriously the idea that the independent state legislature theory is real and should be applied. And look at this. Sam Alito, you saw him before, has said, you know what? I think this is kind of a big issue. It's very important. It's a recurring question of law. With due respect to a man who is much brighter and more learned and more experienced than I am, he's simply wrong about that. Every scholar, including Ahmed and others out there who are looking at this on all sides of the political aisle, whether you're a Republican or a Democrat, everybody who is anyway academic or even non-academic said, this is crazy. James Madison never intended that. And so it's been dismissed roundly. Justice Alito is simply wrong. Brett Kavanaugh says, you know what? It continues to arise. Justice Kavanaugh, no, it doesn't, except in fringe areas and in strange parts of our nation. Yeah, it's still out there and it's been discussed, but not in the mainstream. I'm being generous once again when I say this is a fringe theory. Others would call it a downright loopy, as my nephew did recently. And so just as an aside, we recall not too long ago in 2019, in a case involving political gerrymandering, the Supreme Court, you may recall, said this, a case coming out of Wisconsin and other places. The federal courts are not open to address political gerrymandering issues. That is, the Democrats are over here, the Republicans are over here, and we're going to draw lines. But they can still address things like racial gerrymandering, gerrymandering based upon other immutable characteristics, right? And along the way, in 2019, the Chief Justice, John Roberts, said that
that state courts should continue to hear these challenges, including the context of congressional redistricting. That's a big thing. Why? Because he may well be a swing vote in this case. And he at least is on the record. He doesn't necessarily have to follow what he said before, but he's on the record saying courts have a role. And in the oral argument that happened on December 7th, perhaps a day that continues to live in infamy for a variety of reasons, a great deal of argument about whether or not this crazy theory should be embraced, okay? Next slide. Why is this so important? Well, if you embrace the ISLT and you say, yes, we believe that James Madison intended this to be the rule of law in America, when it comes to the basically districting, that the legislature, the decisions made by the legislature are not subject to review by the courts, by the state courts. No involvement whatsoever. So if you're unhappy about the lines drawn here in Wisconsin, where do you go? Not to a local circuit court or a local appellate court. You go back to the very legislature that decided them in the first place, okay? Gets worse. How about even the rules? Again, I mentioned this issue with timing. If you're upset about the rules, including things like early voting and absentee voting, you go where you go recently, you go to the state courts, right? Under this theory, the answer would be no. You go back to the legislature in Madison and you ask them what they meant when they passed this legislation. Presumably, it would be consistent with the very language that's being challenged in the state court, and they would decide it, and the courts would have no involvement. And here's the big one: electoral votes. If in the future there's a contest about electoral votes in the state of Wisconsin or Alabama or North Carolina, and the decision about who, as we have seen 60 times in this country in the wake of the last election, there were petitions made to state courts and federal courts around the country about what the electoral votes would be, all decided by courts. In the future, under this theory, the courts would have no involvement in that. Instead, where do you go to determine who won the electoral votes? You go to the partisan political legislature, and they will decide who the Wisconsin's 12 electoral votes will be awarded to. Now, in fairness, I know what you're all thinking. Well, gee, here in Wisconsin, we've got a Republican Assembly and a Republican Senate. And so you think about the prospects of that. There are places, as you know, in the United States of America, Oregon, California, other places, we've got just the opposite, where the Democrats are in control. The Democrats could do just the same thing out there. And they could say, you know what? If the Republicans are successful, the Republican majority in our particular state has got the majority of votes here, and therefore winner takes all in most districts, most states. The legislatures in those states could say, no, we think that there was some fraud. We think there's something happened here, and we're going to reverse the popular vote, and we're therefore going to grant to the unsuccessful numeric candidate all the electoral votes in our state, because we have the authority as established by the Elections Clause and by the United States Supreme Court, arguably in Moore versus Harper. This is traumatic, right? This is dramatic as well, and this should scare you even more than Merrill versus Harper. Next slide. The good news kind of is this, and it happened just 2 weeks ago and yesterday. This is your up-to-date news that I bring to you here at 1:15 on a Tuesday afternoon. Good news, maybe for the resolution of this crazy theory, but probably bad news to those of us, including you, I suspect, who are concerned about the disenfranchisement of people of color in North Carolina. November of 2022, last November, the composition of the North Carolina Supreme Court, again, the Supreme Court that said, you've done this wrong, principally, forgive me for being very partisan about this, switched from Democrat majority, Republican majority, okay? And what happened then very recently is, you see 4-3 goes to 5-2, and the state court comes back, and again, on a petition, once again, of the legislature, and they say, you know what, we're going to revisit. We're going to review again this previously made decision by the old court with a different majority. We're going to revisit this decision about whether or not gerrymandering took place, and we're going to revisit the whole thing. And right now, as we gather here at 1:15 on a Tuesday afternoon, they are pondering whether or not in North Carolina to reverse the earlier state court decision. They had oral argument on it just last week. And it's highly likely that the North Carolina Supreme Court is going to reverse the earlier decision of the Supreme Court and find that there was no gerrymandering and the lines in North Carolina are just fine. Now, some of you are shaking your heads and say, gee, how can they do that? They can, if in fact the case comes up. Here's the other footnote to this, and this is why I hesitate to call it, it's not a silver lining at all. The other wrinkle in this, of course, the argument, of course, before the Supreme Court has been in Moore versus Harper that the lower court ruling, the now probably going to be discredited and discharged ruling, is wrong, right? If the North Carolina Supreme Court, look at your watch later today, sometime next week, says, you know what, we're going in the opposite direction, it moots the decision of the federal Supreme Court. And sure enough, the federal Supreme Court, knowing this is going on, just a couple of weeks ago said all the parties in the case pending before us, the appeal from North Carolina, file briefs. Tell us whether you think we should still decide this thing called Moore versus Harper. And so just yesterday, the United States Department of Justice Solicitor General filed a brief that basically said, was very democratically diplomatic, and said, you know what, we think if indeed North Carolina is going to reverse the earlier ruling, there's nothing here for you to decide anymore. And so dismiss this on appeal, send it back, if you will. And probably it appears that the North Carolina legislature pretty much said the same thing. Interestingly, there are some amicus people out there, these amicus is friend of the court, who filed some briefs just yesterday, and they said, you know what, even though we think the ISLT is craziness, no, keep this case, justices, because we want you to send the ISLT into oblivion. Keep this case here and tell us dispositively, Justice Kavanaugh, Justice Alito are right, this is going to continue to come up. Make the decision and tell us it is wrong. More of a risky decision, right? So you can see where this is going. The slight reason why you shouldn't go throw yourself off a bridge over Moore versus Harper as you leave here is just this. Highly likely, bad probably for the people of North Carolina, and especially people of color in North Carolina. North Carolina probably going to be, the Supreme Court going to be reversing the earlier decision, approving of the lines that disenfranchise Blacks. By virtue of doing that, however, they also basically rob a controversy from the Supreme Court. And everybody right now, as of yesterday, is saying, yep, if that happens, nothing more for you to decide, not only on the gerrymandering issue, but also, yes, that's right, ISLT, all goes away, okay? And so the good news is that after all this discussion, it may well be that we escaped a ruling on this. We'd like to think that even if the Supreme Court does resolve this, that normal and rational minds, maybe like the Chief Justice, maybe Coney Barrett would say that yes, James Madison did not intend that, but we don't know that. And the fact that the ISLT has been brought up to the Supreme Court at all should be a concern for you. This is a comparison to JFK is still alive and living in a Dallas hospital, that we never walked on the moon, and that there are little green men from Venus who visit on a regular basis. It is that absurd on a legal basis. And so the good news, of course, is that while the case is right now pending, watch this in the next few days to see if this whole thing goes away. But be concerned, again, the future, not only for North Carolina, and just when you think I'm going to give you all this great assurance about the future, just late last week and again yesterday, the Ohio Attorney General said, you know what, if Harper versus Moore goes away, I've got something else in the hopper. I'm going to bring my case up to the Supreme Court, maybe not in this term, but maybe next term, and I'm going to raise ISLT once again. So it may not go away. It probably won't be decided this term. And that's why those folks who are out there in Washington, D.C. saying, no, decide this and bring it to its end. That's what their motivation is. The fact that it is brought up at all is a concern. We probably have avoided a very bad decision here, but as we go forward, probably not dispositively. JC, the next slide. There they are. And there they are in a sketch. You can go and see the Supreme Court. It's open once again for business. You can stand in line and hear the oral arguments on this and many other kinds of decisions. Next slide, JC. The significance for Wisconsin elections. Well, again, without being partisan at all, what happened in North Carolina can happen here in Wisconsin as well, depending upon who we vote, who we send into the Supreme Court in 2 weeks from today. You may or may not change the composition of the Supreme Court. And if you do here in Wisconsin, you could do what North Carolina did, which is, again, on a new case, you could arguably revisit the lines that were drawn back in 2020. You could revisit all kinds of things. It's got to be a new case in controversy. Someone's got to come forward and say, I was standing, I was harmed by something. But that's why this coming election, among other reasons, the judiciary generally is so very, very important. You could do what North Carolina did, which is revisit some of those issues related to voting as well. Next slide. Along the way, much beyond this discussion today, look at the kinds of things that our United States Supreme Court, among those 63 cases, is looking at. I'll make that very quick. Let's go back just to one. What does the Clean Water Act mean? Is the Clean Water Act constitutional? You probably saw this recently. What about the liability of Google and Twitter and other platforms for things that are posted on their sites? What about the authority of the Homeland Security Secretary to enforce immigration policy? What about the authority of same-sex couples to be free from discrimination when it comes to contracts? A case out of Colorado, once again. Interstate commerce, California, and other states that has to do with pork, believe it or not. Huge case. I mentioned before a case called Tlevsky. This is coming out of the Seventh Circuit. The future of Medicare and Medicaid having to do with whether or not you can petition for abuses, or the remedies for abuses in a nursing home facility. This is a huge one. What about the Indian Child Welfare Act that establishes special provisions in our children's court to ensure that our Native American heritage of children is not dissipated? And here's a big one. FTC and SEC, maybe those aren't constitutional either. That's just a few of the things the Supreme Court's deciding right now and going to tell us about those in June. If you're interested, JC, now, next slide. I was asked to provide some information. We can get these to Ahmed and to others. Here's some great references. This is the official Supreme Court site up there. The one right at the bottom, Ballotpedia, has got a great deal of information there. Just remember Ballotpedia. We'll pull up. A SCOTUS blog is good. Oyez, meaning oyez, all kinds of great references. That's the Supreme Court library. I suspect you visit there all the time when you are checking out books from the Supreme Court. And so with that, we come finally, JC, the last slide, to the end of our discussion today about democracy somewhat in peril this afternoon as we gather together, plainly in many of those other cases, but also when it comes to voting and elections and the future of our nation, our republic, across the United States of America, but also right here in Wisconsin. I've already gone long, but if there's some opportunities for questions, I'd be delighted to take those. Thank you so very, very much. Yeah.
We could take it.
Okay, let's do that. Let's do that. I suspect there are some. Yes, right here. Right. And so what is the process for that? If you initiate a process, you have to amend the Constitution. I'm sorry. Yes, absolutely. The question was, will we ever get rid of the Electoral College? Right. Probably my own view is somewhat anachronistic, especially in a time when we can travel easily between states, no longer the kind of thing that James Madison, I think, anticipated. How do you do that? You have to have a constitutional amendment to do it. Both houses of Congress have to pass it, and 2/3 of the state have to agree to it also. That's a very, very, very heavy lift, at least today. Right? Not impossible to do, just like changing again. If you want to change the tenure of Supreme Court justices, you can do that by a change in the Constitution. My own view is we are probably overdue on that issue, but it is a very, very difficult thing to accomplish under the process. Maybe do one other question. Yes, right here.
Referring to the Dobbs decision.
Yes, last June.
Overturning.
Yes.
A couple of the prospects for the nominees for the Supreme Court over the past 2 years have been asked specifically during their interviews whether they are committed to the concept or the practice of stare decisis.
Right. And privacy rights.
That they were strongly committed to that, and then afterwards ignored that and went against it. And what about the honesty of the answers in the interviews? Can we just forget about that?
Right. So the question is, in the wake of Dobbs, of last June, again, overturning 49 years of Roe versus Wade, establishing reproductive rights in America. And following up on, since 1965, we have had the concept of privacy rights in this nation that affects not only reproductive rights, but also decisions about how you define your family, same-sex and interracial marriage, all kinds of things about medical care and treatment, many, many things involving privacy rights, arguably potentially compromised by a decision in Dobbs. The question is, when Supreme Court justices, including Amy Coney Barrett and Neil Gorsuch and Brett Kavanaugh appeared, and frankly, all the other justices always are asked these kinds of questions. Recently, they have all said that is the law of the land. That was their response, right? And you can make the argument, okay, that is literally true, and that their statement about that is not an out and out lie about things, but they plainly were evading the question at the time. And your point, which I'm going to take to be simply rhetorical, is about the honesty that we should bring to those proceedings. You can make the argument that they should not be asked about those things at all on both sides of the political aisle, right? You should ask about judicial philosophy and your approach to broad principles about separation of powers and things that are sort of established in our national jurisprudence. I also find that very troubling. And it is a reflection, perhaps more than anything else, about the political arena that we live in right now that affects we were talking at our table right here before about the judiciary generally. That those kinds of things should not be the subject of analysis. We should identify judges and justices who are bright, hardworking, have integrity, have ethics, and yes, they've got political views, but they should do what we command them and ask them to do, which is apply the law to the facts impartially, without partisan perspective. Question, and I think this goes to your point, whether we have that going on right now in our federal courts and in our state courts as well. I will be, we need to conclude. All right, very good. Thank you so much. And I'm just delighted to be with you today. Ahmed, thank you so very much.
Thank you so much. Thank you so much, Jim. Again, I would like to thank Jim Santelle for our wonderful presentation, scary and wonderful, but at the same time. And a reminder again that we are back here again next Tuesday for our fourth and final Tuesdays in March, when Lee Hawkins, a journalist, Marquette O'Brien Fellow winner, is going to be speaking on the interaction between democracy and faith, and for either good or bad in the history of this country. Lee Hawkins is an African-American journalist now with American Public Media. He once worked at the Journal Sentinel here. He worked for almost 20 years at the Wall Street Journal as well. He and David Omhofer, who also is from the journalism school at Marquette, they are going to have an interactive interview discussion about this, but there will obviously be opportunities for questions as well. Everyone online also, we look forward to your participating next week. And I have a couple more announcements that we can handle offline now, but thank you so much everyone for joining us. Again, there are two other issues now then that I will remind everybody about. First of all, there is voter registration and voting information at the back table. As Pat McFarland said, League of Women Voters information and the like. And also, as Jean Manch announced earlier, we are looking at having a regular potluck gathering. We'll figure out the virtual and the First Unitarian location as well. But we look forward to continuing the dialogue, and we look forward to seeing you all next week. Again, thank you so much for coming. Have a good afternoon.